Welcome back to this channel where we provide premium legal content. Today, we want to look at the topic privity of contract. By the end of today's video, we will be looking at, or we would have learned, what is privity of contract, number one. Number two, we would have learned the importance or why privity of contract is important. And number three, we would have also looked at examples of privity of contract. And number four, the exceptions to the principle of privity of contract. But before we look at all of this, it's important that I crave your indulgence to please subscribe to this channel so that you can continue to enjoy premium legal content that drops on this channel. With that done, let's look at what is the meaning of privity of contract. And of course, you should also remember that in every contractual agreement, there are basic ingredients. Number one, there must be an offer from one party and acceptance from the other party, whose mind are ad idem, meaning that their both minds have met together and they have agreed after the payment of consideration, either from one party to the other, to perform a particular agreement. But with that said, let's move to the meaning of privity of contract. Privity of contract basically means that if a person is not a party to a particular contract, that person cannot be compelled to, perform the terms and condition in a particular contract. The person can also not sue for the enforcement of the terms in the particular contract. Let's look at why this is important. This is important because it protects third parties, or it protects parties to a contract from undue interference from third parties. Now, this will become clearer when we look at the examples. Let's look at examples to privity of contract, and we'll give you 3 examples. Take, for instance, number 1, X and Y enter into an agreement to give a yellow tie to A. And in the event that X fails to give that yellow tie to A, can A sue X to perform the terms and conditions in the agreement between X and Y? Well, that's going to be difficult. Why? The reason is simple, because A is not a party to the agreement between X and Y. And because despite the fact that the agreement between X and Y is made for the benefit of A will be unable to sue because A is not a party to the agreement between X and Y.